A special treat here today at the Four Boxes Diner. We have the audio of the oral argument in the U.S. Court of Appeals for the Fifth Circuit between the ATF and the Second Amendment lawyers in front of that three-judge panel. I'm going to play for you some snippets of that argument so you can see the kinds of things that Second Amendment lawyers have to go through when they go to court to fight for your rights. It's important for you to hear some of this back and forth. It makes you smarter about what we do here on this channel and in scholarship and what the lawyers do, just to understand how the system works. And this, I think, will help you when you listen to this oral argument in the Reese case involving 18, 19, and 20-year-olds of whether or not they have Second Amendment rights, and of course the methodology that's applied to interpret our Second Amendment rights, which will go far beyond this particular case into all sorts of other areas involving Second Amendment jurisprudence. Stay tuned. We're going to break it down when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the best-selling book, Israel Disarmed, What the 10/7 Attacks on Israel by Hamas Teaches Americans About the Right to Bear Arms. Check it out on Amazon, and if you have a copy, feel free to leave a review on Amazon. Also, if you're going to be in San Diego this week, San Diego, California, I'll be at the Gun Rights Policy Conference for the Second Amendment Foundation. So if you're going to be out there in San Diego, feel free to stop by, say hello. I know we're giving away a considerable number of books that I'll be there available to sign and whatnot. So feel free to stop by San Diego, the Gun Rights Policy Conference this coming weekend. Look forward to talking to some of you out there. Okay, with that said, here we are. We had a big argument this week in the Fifth Circuit Court of Appeals down there in Texas, Louisiana, involving 18, 19, and 20-year-olds, and a constitutional challenge as to whether or not it's legal for the federal government to say that 18, 19, and 20-year-old Americans are not allowed to buy handguns from FFLs. Big Second Amendment fight. There was a lot of back and forth between the three-judge panel. I think we're going to win this case. We've talked about this Reese versus ATF case before, which is the title of this case. I think there's a very good chance that the Fifth Circuit is going to declare this law to be unconstitutional. Then the Department of Justice will seek cert from the U.S. Supreme Court, which will likely be granted. And this case, I suspect, will eventually get to the U.S. Supreme Court on the merits. So with that said, I want you to hear some of the back and forth between the lawyers and the judges. So to begin with, let's hear the opening statement from the pro-Second Amendment lawyer arguing in favor of the Second Amendment against this gun regulation right here and right now.
Good morning, Your Honors, and may it please the Court. John Ohlendorf for the appellants, and with the Court's permission, I'd like to reserve 5 minutes of time for rebuttal. As the Supreme Court held in Heller and Bruin and has now reaffirmed in Rahimi, the constitutionality of Section 922's ban on 18 to 20-year-olds' commercial acquisition of handguns must be assessed based solely on the Second Amendment's text and its history. Now, as I submitted to the Court the last time I was before you, Section 922's ban cannot survive that crucible.
That was a great opening statement, but then we also have a very interesting observation by the judge. Remember, there's a discussion here about, are we in a free country or a totalitarian country? And what do I mean by that? As you know, in free countries, we get to do anything we want to do unless the government bans it. This is in stark contrast to, let's say, authoritarian or totalitarian countries where it's just the reverse, which means you're not allowed to do anything unless you get the permission of the government first. Let's check out this colloquy between the Department of Justice lawyer arguing for this gun control law and the federal judges about whether or not there's a presumption of freedom in the Second Amendment. Check it out.
So, Your Honor, I would point you to Justice.
I sort of resent this argument that you have, you have certain qualifications, and that made it permissible. We live in a society where the presumption is freedom, unless the people have determined through their legislators to limit freedom.
Your Honor, the goal of Bruin and Rahimi's historical inquiry is to figure out what the ratifiers would have permitted. That's necessarily a larger category than what they actually did. Legislatures today don't go to the full extent of their authority.
If you have minimal evidence of limitations, then you have maximal evidence of freedom.
Your Honor, I think both Rahimi...
the exercise of rights, in personal rights.
Your Honor, to the extent that's a way of saying that, silence should be dispositive in a case like this, that's not what Rahimi does. Again, we just didn't have a domestic violence law.
The point of disagreement between the majority and Justice Thomas is at what level of generality do you apply the history as relates to that particular question? There's no doubt that Mr. Rahimi was a bad facts case, and that people, you can generalize that domestic, I may not agree with that, but I'm overruled, that domestic relations orders of that sort reflect the propensity for dangerousness. You can't really generalize back to the 18th century that 18 to 20-year-olds represented a propensity for violence.
I respectfully disagree, Your Honor. I mean, the fact that as soon as legislatures started to write these laws down, these age qualifications, that they did almost exactly what Congress says.
100 years later.
Less than that, Your Honor. I mean, I think our earliest started in the 1850s, and so 60 years.
You have one in the 1850s, right?
I believe that's right, Your Honor. I mean, that no one thought of that law as a problem. 20 laws joined it today. 30-plus states have similar laws. I mean, I think one problem with their approach is that it takes what legislatures have been doing for most of American history and makes it irrelevant to this test, which is supposed to be all about history. That's not what Rahimi supports.
It's all about the original history of the Second Amendment. It's not about the evolving standards of justice. Quite different, right?
Your Honor, of course this is about the history of the Second Amendment. I guess we've talked about the problems with their militia-based evidence. Other than that, that's really all the history that they have. We're the ones who are putting before the court age qualifications that are most closely related to the restrictions that are at issue here.
Fascinating back and forth here. Now, of course, one of the other things that was discussed, and the reason why this three-judge panel wanted to hear this case again in oral argument, is they wanted to know whether or not the Rahimi decision from June of 2024 had any impact on this 18, 19, and 20-year-old young adult case. And here basically is an indication that it really doesn't matter. But let's check out what is said in open court about whether or not Rahimi matters to this particular case.
You're going to touch on Rahimi?
Yes, Judge Jones. So we don't think Rahimi casts any doubt on the conclusions that I submitted to Your Honors last year. In fact, we think in several respects it bolsters them. Rahimi, we think, was really just a routine application of the text and history standard articulated in Bruin, which Rahimi reaffirms. Rahimi does, to be sure, it clarifies that the founding era going armed laws are appropriate analogs for the provision of Section 922 that disarms those who pose a threat of domestic violence. And it clarifies that those founding era laws are appropriate analogs, notwithstanding the fact that they targeted a threat of public violence rather than private violence. But that line of analysis we don't think offers any help to the government here because, again, the government has not identified any laws. It has zero age-based firearm restrictions at the founding. So the situation is totally unlike that in Rahimi.
Fascinating conversation there. Now let's talk about the Militia Act. As you know, we've talked about this before. The Second Amendment and the Bill of Rights was adopted in the year of our Lord, 1791. What happened in the year of our Lord, 1792? Well, it was very important. The Militia Act of 1792 was enacted by Congress as a national standard for age of militia members. And 18, 19, and 20-year-olds fell within that because the age of people in the militia were men, free men, 18 to 45 years of age, were in the militia. And this is particularly important because under the federal law, again, a national standard, not a state standard, a national standard, they had an obligation to bring their own firearms with them to militia muster. So how on earth could 18, 19, and 20-year-olds be even possibly able to comply with that requirement if they weren't able to acquire guns privately in the first place and then, in turn, bring them to militia musters? And the court discusses that right here and right now.
At the founding, they required 18-year-olds to show up for militia duty with their own gun.
So, respectfully, Your Honor, that's not what Rahimi did. I mean, Rahimi didn't look at militia laws and say...
Well, because they weren't relevant. They are very relevant in this. I mean, I don't think you can honestly discard them 1791 or 2 Militia Act.
Your Honor, the fundamental problem with the militia evidence that the other side has pointed to is that using a musket in a highly supervised context doesn't imply a right outside of that supervised context to have a handgun.
You're talking about the importance of age qualifications, and 18-year-olds had to produce their own weapons for the militia.
So, Your Honor, respectfully disagree with a couple of the factual premises in there, so if I can just unpack two of them. One is that militia laws were always at 18. The age actually fluctuated, so we pointed to Virginia.
Not under the federal law.
It did under the federal law as well, Your Honor, so we pointed to the highest court of Massachusetts issued an opinion saying, yes, of course, if states want to, they can go up to 21 under this law. And I think that's consistent with our argument that, both at the founding, even in these militia laws, 21 was within the accepted range. It was also within the accepted range, of course, when legislatures got around to codifying these kind of age qualifications. Related to that, I thought I heard my friend on the other side acknowledge that firearms technology changed dramatically in this period.
And again, the Department of Justice lawyer worked really hard trying to argue that Rahimi somehow helps his case to justify this modern-day gun control law. But I'm not sure how well it's going to go. Check out this explanation by the Department of Justice arguing for the ATF right here, right now.
I'm puzzled because it seems to me that your whole argument is premised on some idea that Rahimi changed the landscape quite a bit. And the majority of the court, I think the whole court actually on this point, said that Bruin is still the test. And would you be arguing under Bruin that, I guess you did, but what argument? It doesn't seem that you actually have a basis to argue because we don't have the historical analogs that we had in Rahimi. It doesn't. I don't understand your argument. So can you maybe help?
Of course, Your Honor. Thank you. So Rahimi, of course, is applying the Bruin test. It clarifies that test in a couple ways. One is this focus on historical principles. The historical principle that we've identified is that age qualifications are permissible. You can think of that as reasonable age qualifications. You can think of that as 18 to 21. Either way, these restrictions are permissible. Your Honor asked about sort of what our historical evidence is for that. We've discussed at length this post-ratification sources. Justice Kavanaugh's concurrence and Justice Barrett's concurrence explain why those sources are important. From the founding, I'll highlight 3 categories of evidence that we haven't discussed in detail yet. One, of course, is the age qualifications on other activities. 2 is the absence of any evidence that anyone thought these kind of qualifications were impermissible.
Okay, well, the last point I want to discuss is Judge Jennifer Elrod discussing the role, if any, of what's known as post-ratification history. We know that the Second Amendment was adopted in 1791. We also know that the Supreme Court has said you start with the text of the Second Amendment that articulates the right, and then to the extent there's some sort of historical tradition firearms law that restricts the use of a firearms law in some particular way and has gone back to the time of the founding, the example I always like to give is there is no constitutional right to commit cold-blooded murder, and although that's not in the text of the Constitution, if you look at the history surrounding the adoption of the Bill of Rights and the Second Amendment, obviously, it was well understood that no one was allowed to use firearms or any weapons, for that matter, to commit cold-blooded murder. And therefore, the right to commit cold-blooded murder does not exist in the Second Amendment, even though it doesn't specifically address it with the text. We know this from the history surrounding the adoption of the Second Amendment. You can't use a gun to commit cold-blooded murder. But with that said, there's a big debate. Not really a big debate. I think I'm pretty much going to be completely right on this. I've written about this before, as to whether or not the 1791 time period is the relevant historical period to look for gun control laws to establish a historical tradition of firearms regulation, or Do you look at the late 19th century, specifically 1868, after the Civil War, when the adoption of the 13th, 14th, and 15th Amendments, what matters here is the adoption of the 14th Amendment, dealing with what's known as the Substantive Due Process Clause, which is the means by which the Second Amendment and the Bill of Rights gets incorporated and applied to the states and localities, so that states and localities can't violate the law, can't violate the Constitution. So the question is, which is the time period, 1791 or 1868? And the court flagged this as a question, but I think it's pretty clear that history after the founding period is too late in time. There's a bunch of reasons for this we've talked about in the past. But let's hear what the judge has to say. This is Judge Jennifer Elrod discussing this in the Reese case right here, right now.
Why doesn't this run afoul of Justice Barrett's warning that post-ratification history unmoored from original meaning is not binding law in this context?
Your Honor, Justice Barrett explained that there are a couple scenarios where post-ratification history can be important, and let me explain why both.
But it seems to be unmoored here.
What?
Unmoored. It's unmoored from the original meaning here.
I disagree with that, Your Honor. I mean, these were people within a lifetime or two of the founding. It wasn't as though there was some founding era evidence that no, the reason legislatures didn't pass these kind of age qualifications on arms, the reason is that we think that would be some kind of Second Amendment problem. The other side hasn't identified any ratifier, really any evidence from the founding that they thought these kind of laws would be impermissible. And Justice Barrett also pointed out the problems with assuming that legislatures acted to the maximum extent of their authority. She said that would be an error and that the courts need to look at the history at a higher level of generality than that.
But not at the highest level where you could say someone is just not responsible, which is what Rahimi rejected.
That's right, Your Honor. Rahimi rejects responsibility as a label. What the court took pains not to reject was this idea that legislatures can restrict arms bearing by groups that present a special danger or a heightened risk. Congress identified this as one such group, as did historical legislatures.
I'll give you one.
All right, folks. Well, I hope you learned a little bit something here today. The back and forth in the Reese versus ATF case about 18, 19, and 20-year-olds and whether or not they are entitled to full-blown constitutional rights to acquire firearms and the like. I think the answer is undeniably yes. I think this is a relatively easy case to rule in favor of the Second Amendment against the government. But again, only time will tell as to what really goes on here. I think if the Supreme Court ever gets this case, we will win this in a slam dunk. But again, anything's possible in today's world. You can't predict everything all the time, but I'm pretty good at this, and I think this would be a slam dunk if it ever gets to the Supreme Court, and I think we're going to win this case in the Fifth Circuit as well, but again, only time will tell. All right, folks, hope you learned something here today. Make sure you follow me on X at 4 Boxes Diner. We have over 18,000 followers now. Please subscribe and like this video. We're trying to grow the channel. I know we're very far behind a lot of other Second Amendment channels, but we're working hard to try to catch up, and we look forward to seeing you again here very soon at the 4 Boxes Diner.
Orders up. Table 2A.